Sure, it's clear. The violation with respect to Dr. Meehan, there is no requirement for an agreement. It's not a 3.6A violation. It's a separate violation. It's a request. And there is no legitimate reason to ask for a report with the matches. You don't have to use magic words to have a violation. If you have an explicit consent or agreement, that's a 3.6A violation. That's not what this is.
Alleged there is no legitimate reason for Mr. Nifong to request a report with the positive matches. And that is not the only thing consistent with the evidence here, is that's what he's asked for. That's what he got. That's what they went over with him at the meeting, according to everyone's testimony. And if that's not what he asked for, it would have been obvious. He also said it in his answer. That's a violation. I do want to point out that in these transcripts, we've been talking a lot about his representations about what's in the report. It's very important to note that there are representations in those hearings, not simply about what's in the report, but independent of what's in the report, what was discussed with Dr. Meehan. The June 26th is a great example. There's not a discussion in there about what's in the report. It's a discussion about what was discussed with Dr. Meehan. And so independent of whatever's in the report, he's saying there was nothing discussed at this meeting beyond attorney work product. And he has been at these meetings. So in addition to having to believe that he didn't know about the report, hadn't read the report, never went back and read it, you'd also have to believe that he had completely forgotten about these 3 meetings with Dr. Meehan that had happened a month or 2 earlier. With respect to the December 15th hearing and why would he do this and why would he possibly do this, I would submit to you, if you look through the responses that happened fairly close in time in this case, I think you could certainly draw a conclusion that looking that far ahead and making sure you were consistent and logical is not necessarily a conclusion you should draw in this case. There are repeated inconsistencies within these responses and representations, as we pointed out, that don't appear to be logical to somebody facing serious charges. And I think it would be a mistake to some conclusion to say that you had thought sometime down the road you did all this, but it doesn't make any sense because sometime down the road you might get caught. And the other important point about that is that what happened in this case, as you know, is a report that was provided that looked like a final report, and then some underlying data from which you would have no. It's not like just the underlying data was provided. It is especially misleading to have a report that looks like the final report and then produce the data because you assume that's what's in there. And so I think it is not at all a good or fair assumption to assume that he would have never done this because he knew he would get caught eventually down the road. One thing about the Attorney General's report and why they thought didn't think this was important, I think a very logical conclusion to draw from the Attorney General's report about the DNA evidence and whether it was significant is that the Attorney General didn't need to nor want to get into issues that were pending in another forum about DNA. It wasn't necessary, and I think that's just not.
Well, it wasn't finding that there was an absence of DNA evidence linking the accuser to the defendants, as I recall.
Right, but as relates to what was not disclosed, that was an issue that the Attorney General obviously knew was pending in this forum, and they certainly could have decided to not address that issue for specific reasons. So I think that would be a mistake. My last point.
Indeed, I'll just state, of course, that the Attorney General was dealing with the issues of the underlying criminal case, and those are not the issues while they are related, they're not the issues that we are dealing with in this disciplinary action.
I understand.
That's a statement.
I understand. No, I understand. I'm just saying that you cannot draw the conclusion because it was not in the AG's report that necessarily they didn't think it wasn't important. And the last point I would come back to is that we've focused a lot in the last little bit about the DNA, but it is important to consider in looking at intent, as the Chair pointed out, all the circumstantial evidence. And as you look through this case, from the beginning to the end, there is an overwhelming amount of circumstantial evidence that indicates that this was not a mistake. The violations of the pretrial statements up to the very end of this case, the circumstantial is clear, cogent, and convincing where it is circumstantial of intent, and of course directly on the other issues. And the State Bar would ask that you find all the violations. Thank you.
Legendary status as the region's true home of the blues. That town was Durham. The railroad not only played an important role in Durham's blues heritage, it also helped influence the development
submitted by the parties. What I'm going to do is to read each of the contested issues that are listed in the pretrial order, and then to indicate yes or no, and in some cases with some explanation, but generally without any further elaboration. We'll have further elaboration at the conclusion of Phase 2 as to certain matters. And bear in mind that there are 19 issues, some of which are duplicative, and some of which reflect that there were amendments to the applicable rules during the period we are talking about, so that you'll hear what sounds like pretty much the same thing. A yes will signify that we have found the issue to be proved by clear, cogent, and convincing evidence, which is the standard of proof applicable to the bar's allegation. A no simply means that there has been a failure or an absence of proof to the standard of clear, cogent, and convincing evidence. The first issue reads as follows. Did defendant make extrajudicial statements to or in the presence of representatives of the news media, including those set forth in paragraphs 12 through 177 of the amended complaint? Yes. 2. Did defendant know or should defendant reasonably have known that his extrajudicial statements set forth in paragraphs 12 through 177 of the amended complaint would be disseminated by means of public communication? Yes. Did defendant know or should defendant reasonably have known that his extrajudicial statements set forth in paragraphs 12 through 177 of the amended complaint would have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter in violation of Rule 3.6a? Yes. 4. Did defendant's extrajudicial statements set forth in paragraphs 12 through 177 of the amended complaint have a substantial likelihood of heightening public condemnation of the accused in violation of Rule 3.8f of the revised Rules of Professional Conduct? Yes. With this further note of explanation, it will be necessary for us to have a finding, I believe, that the accused in this instance includes the set of suspects, that being the lacrosse players that were at the house on the night in question. And it's not necessary for us to make a finding as a legal matter that they were actually indicted or criminal defendants at the time. 5. By making misleading statements to or in the presence of representatives of the news media, did defendant engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4c of the revised Rules of Professional Conduct? No. A word of explanation there. The one statement at issue there involving whether or not condoms might be involved is, to our mind, no worse than certain others that were not alleged to involve dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4c. For instance, the statement to the effect that the accused were not cooperating. And since it was not alleged that those statements involved an 8.4c violation, we do not think it is appropriate to pick out this particular one and say that it is. Although we have the option, as a matter of law, of finding some of the other statements to also include a Rule 8.4c violation, we decline to do so. Number 6. Did defendant, by not providing to the Duke defendants prior to November 16, 2006, a complete report setting forth the results of all tests or examinations conducted by DSI, including the potentially exculpatory DNA test results and evidence, A, failed to make timely disclosure to the defense of all evidence or information known to him that tended to negate the guilt of the accused in violation of former Rule 3.8d of the revised Rules of Professional Conduct? Yes. B, cell phones off. B, failed to make a reasonably diligent effort to comply with a legally proper discovery request in violation of former Rule 3.4d of the revised Rules of Professional Conduct? Yes. Did defendant, by not providing to the Duke defendants prior to November 16, 2006, memorializations of Dr. Meehan's oral statements concerning the results of all examinations and tests conducted by DSI in written, recorded, or any other form, A, failed to make timely disclosure to the defense of all evidence or information known to him that tended to negate the guilt of the accused in violation of former Rule 3.8d of the revised Rules of Professional Conduct? The answer is yes, with the proviso that the way that issue number 7 is worded with the word memorializations tends to imply that the violation is premised on violation of the discovery statute rather than 3.8d. We think for purposes of issue 7a, it may be more appropriate to call that communication in any form of Dr. Meehan's oral statements, and not to say memorializations. B, 7b, failed to make a reasonably diligent effort to comply with a legally proper discovery request in violation of former Rule 3.4d of the revised Rules of Professional Conduct. That answer is no, based upon the converse of the distinction in A. That is, to the extent that that is based upon compliance with the discovery statute, at the time there was evidence that the Attorney General took the position that prosecutors did not have to provide such memorializations, and therefore there is a plausible reliance by the defendant upon that position at the time, which is no longer the law, of the Attorney General, and that is the basis for saying no to 7B. 8, the defendant, by not providing